Welcome to Spectacle on Television Nigeria. I am your host, Daniel Atai. In today's spectacle on your favorite station, we shall be looking at the constitutional provisions for the following. Number one, the contempt of court on national interests by the federal government. And number two, the disqualification of Bayelsa State APC Deputy Governor candidate. And number three, the Edo State suspension of the APC National Chairman Oshomole. Then we'll briefly look into proposed bill prohibiting hate speech that may attract capital penalties depending on the degree of hate speech. So welcome to Spectacle, your socio-political and economic program on Television Nigeria. I am your host, Daniel Atai. And without wasting your time, let me introduce my guest analyst, who is a constitutional lawyer that will be doing justice to them from the angle of the law and constitution. He is John Ochogu Esquire. Welcome to Spectacle, sir.
Thank you very much. I'm grateful to be on your platform this afternoon.
All right, sir. Did I get the introduction right?
Yes, you did.
Okay. Now, again, we shall be hearing from another constitutional lawyer in the person of Joseph Agu Esquire, who will be calling from Enugu State, southeastern state of Nigeria, to give us his own take. Now, on the contents of court, we'll begin immediately. We'll start with Omoyele Sowore, of course, a former presidential candidate of the African Action Congress and a publisher of the Sahara Reporters, who was on August 3rd, 2019, arrested by the DSS in Lagos and transferred to Abuja. The DSS obtained an ex parte order to keep Sowore for 45 days, barely 24 hours due to the expiration of the 45 days detention order. The Office of the Attorney General of the Federation filed charges of treasonable felony, cybercrime offenses, and money laundering against him before the Federal High Court in Abuja. But his lawyer, Femi Falana, applied for his bail pending his arraignment. Also, Justice Taiwo of the Federal High Court, Abuja, granted the prayer, while Sowore has since filed a case of contempt against the DSS boss, Yusuf Bichi, for failing to comply with the court order granting him bail. Now, we'll stop there for a while. Meanwhile, the program is open for audience participation, and the numbers to call are on your screen. And for the sake of the vision impaired ones, you can dial us +234 81 3701 5949 or +234 705432 7616. You can call concurrently as the analyst and the barrister have a say on the particular topic. Now, barrister, over to you, sir. As a constitutional lawyer, the federal government on 2 or 3 occasions have come out to say that what they are doing by flaunting court orders are based on national interest. We want you to help us on this regard, sir.
Well, like you rightly captioned, the Federal High Court sitting in Abuja, presided over by Honorable Justice Taiwo, did grant an order directing the Director of State Security Service to release a former presidential candidate, Mr. Sowore, on bail. And as of today, we are all aware that the DSS has refused and failed, to comply with that order. Like you rightly pointed out, oftentimes the Attorney General of the Federation has always defended their inability to comply with this kind of orders based on what they conceive, to be national interest. Probably that the order of the court, is against national interest. But the question that arises here is, who determines what is against national interest.
Okay.
And I dare say that whether the Attorney General or any member of the executive, lacks the powers, to interpret, a situation that, that is
refers to as national interest.
That is in conflict with what they call national interest. The executive, they enforce our laws, and as we have it under this presidential system of government, the courts are available to interpret, situations of this kind.
Okay. So
if you consider, a bail granted to a citizen of Nigeria to be against national interest, what you are expected to do, as a law-abiding citizen or government, is to go back to the court and say, this order that you granted, we consider it to be against national interest.
Okay.
Therefore, either revoke the order or you appeal against the order. Under these circumstances, nothing like that has been done, and what they continue to do is to disobey the orders of court, and I think that is not too good for our nation, currently.
All right.
Yes.
Now, and if I may ask you, could you give us any interpretation of what could be termed national interest?
Okay. For example, so many years ago, I do remember that when Asari Dokubo, one of these foremost militants in the Niger Delta, had matters in court, and an application for his bail was filed before the court, the Federal High Court. The government came up and said, look, if you release this man, it will impede on our national interest. It will be a threat to our national interest. And I think that, in that matter, the court took time to explain, what will be in conflict with national interest. For example, now, if you think that if you release a suspect or, a defendant who is standing trial, in court, to have his freedom to go, have his way, in the country or in the society, if you consider that such release will be against national interest. For example, if you think that if you release a particular, accused person and he would threaten, the existence of Nigeria, or maybe he would do anything that is inimical, to the existence of our nationhood, then that will be considered to be, an order that will be in conflict with national interest.
Okay.
Yes.
And are there cases, are there sections in the Constitution that defend the government to flout court orders?
Well, I don't know of any provisions under any of our laws, whether under the Constitution or any other subsidiary laws that protect, a continuous, detention of a citizen based on national interest. I am not aware of any provisions of our law. On the contrary, the Constitution expressly states that if you suspect a person to have committed an offense, you can keep him within 24 hours if there are no courts within the vicinity to charge him to, or maybe 72 hours the most, where there are no courts within, available for you to charge the person to. But if after 72 hours at the most, you are expected to charge the person to court, and once the person, has been charged to court, the court can make orders, in the interest of justice, one of which is to either refuse the person's application for bail or retain or grant the person's application for bail. Like you said earlier on, issues that may be considered to be of against national interest. I just let me put in this word now. For example, if a man sincerely and genuinely set out to topple a government, maybe committed treasonable offenses, under such circumstances, the court can say, okay, we will not grant this man bail because why? He wants to topple the government of the day. That is against national interest.
And don't you think, national interest in this case is also a kind of a revolution or security interest, because in the case of Sowore, that was exactly what they said. The court said, the DSS said, treasonable felony.
Yes, they actually said so. But I believe that those facts were made available to the court. The court considered them, looked at them, and felt otherwise. And I believe that was the basis upon which the court proceeded to grant Sowore bail.
Okay.
And having granted that bail, it is incumbent on the DSS to comply with the order of court. Because by refusing to obey the court, they have constituted themselves into a court of law, and that is not what is envisaged or anticipated under our constitution.
All right. Oh, while we'll still dwell on that, we'll give another situation of where we have seen that the FG or probably the DSS have, flouted court order in the case of Zazaki, and I think the DSS have kept Zazaki since 2015. That is December 2015, following an altercation between members of the Nigerian Army and the IMN in Zaria, Kaduna State. On December 2nd, 2016, Justice Gabriel Kolawole of the Federal High Court in Abuja ordered the release of the leader of the Islamic movement in Nigeria, Ibrahim Zazaki, and his wife, Zinat, from the custody of the Department of the State Services. Aside the order of the court to release them, the court also ordered that the DSS should pay the couple the sum of 50 million as compensation. But the order is being flaunted for national security interest. However, the IMN leader is standing trial in another court over allegations of culpable homicide, unlawful assembly, and destruction of the peace of the public peace, among other charges. Again, we have the issue of Colonel Dasuki Sambu, retired, who is also in the DSS custody, and the court also ordered for his release. Is it that the court is not interpreting very well, or our constitution have loophole in interpreting what is national interest or what is court order?
Well, it is not that the court have problems with interpreting our laws. To the best of their knowledge and ability, they have interpreted the laws the way they understand it to be. The problem here is the position of government not to comply with these orders of court. The problem is not that of the court. Okay. You understand very well that we have three arms of government, under our constitutional democracy. Yeah. We have the legislature that make these laws. Okay. We have the executive that implements these laws. Then you have the judiciary that interpret these laws. No, when matters are filed before court of competent jurisdiction, it is their duty to look at the facts and the law and to give an interpretation one way or the other. In the cases that you have mentioned, whether Colonel Dasuki Sambu or Zaki, all these issues of national security were presented before the court, and the court looked at them and said, no, these matters do not amount to issues that can infringe on our national security. Therefore, I am granting these personalities bail. But the problem, like I said, is that of compliance, with these orders of court. And the moment you refuse to comply with orders of court, what you do is that the confidence of the people on this system, will dwindle. Because and the other implication is that it will be a subtle invitation to anarchy. Because if I have problem with another person and we go to court and court makes orders